Hey everybody, Bill Sack here, your favorite attorney with the Firearms Policy Coalition legal team. Having unboxed our brand new for 2022 high-speed lawsuit printer, your FPC legal team was eager to try her out. So we went ahead and filed two new lawsuits this week. The first is Newton v. United States, a new lawsuit that challenges the federal government's wrongful denial of an application to purchase a firearm by adopting a burden-shifting policy that forces gun buyers to prove that they are not prohibited persons under the law, as opposed to the way the constitutional rights are supposed to work, wherein folks maintain their full panoply of rights unless and until the government has proven that those rights have been lost. See, in 1981, Ralph Newton was convicted of 2 federal misdemeanors for disorderly conduct and assault for his role in a bar fight in the Yosemite Valley. As a result, he paid a $50 fine, was sentenced to 6 days in jail, and placed on 1 year's probation. Nearly 4 decades later, Newton was denied the purchase of a firearm for self-defense by the federal government. The government claims Newton's convictions could have been crimes of domestic violence, despite having no supporting evidence. However, the government has long since destroyed the 40-year-old records and unconstitutionally placed Newton in its prohibited persons list. The government further enforced its policy and practice of shifting the burden of proof, requiring Newton to prove, with the court documents the government itself had destroyed no less, that he is not prohibited, rather than the government proving that Newton is prohibited with sufficient evidence and due process. The second case FPC filed last week was Brandeis v. California Attorney General Rob Bonta, a lawsuit challenging California Assembly Bill 173, which requires the state's Department of Justice to share the personal identifying information of millions of gun and ammunition owners with other parties for non-law enforcement purposes. Disclosure of plaintiffs' personal identifying information constitutes a severe privacy intrusion that is not adequately tailored to or justified by the state's purported research interests, the complaint states. By forcing citizens to sacrifice one constitutional right, the right to privacy, in order to exercise another, the right to keep and bear arms, AB 173 is unconstitutional. Additionally, the complaint says that the legislature exceeded its power by eviscerating Proposition 63's voter-mandated privacy restrictions and amending the statute to make personal information in the ammunition purchase records file available to researchers on the same terms as the automated firearm system data. Now, as always, you can read the complaints in Newton, Brandeis, and all of the other cases your FPC legal team is involved in their entirety, at fpclaw.org. I'm Bill Sack, your favorite attorney with the Firearms Policy Coalition legal team.